Afternoon, everyone. I'm Trevor Moffat from the Improvement Service, and it's a planning skills session with Nature Scott on habitats regulations appraisal. This is the second event we've ran in this series of events. We've done an introductory session on the 20th of May, and if you've not already seen the materials for that, I'll post them in the chat shortly. As I said, I'll just do some quick housekeeping. I'm joined today by John Kerr, Fiona Rice, and Viv Gray from Nature Scott, who will be presenting today.
Hi, good afternoon, everyone. As Trevor was saying, I'm John Kerr from Nature Scott. I work in our protected areas team, and I cover quite a lot of stuff to do with legislation, casework, designation of protected areas. I was also leading on the first session that we did of this that Trevor was talking about. So many of you probably have seen me already. This is a second session that we're doing, which is covering much more sort of some of the sort of more technical aspects of HRA. Trevor, can you move to the next slide, please? So what we're going to cover today is, sorry, the EROPI derogation, which is the sort of final part of the HRA test. And then Viv, my colleague, is going to cover what the process is HRA for local development plans, and then back to me to pick up a few sort of final big topics that either cropped up from the last session that we did, or there are far more technical. So a bit more on the difference between intrinsic and bespoke mitigation, a bit more on cumulative effects and what should be taken into account for that, and probably quite a big topic that is of interest to a lot of people is where permitted development and HRA interact. It's not a huge number of topics we've got there, so we've got a lot of time for questions at the end, which probably people will find hopefully quite useful. And as Trevor said, there's various sort of questions and sessions put into Mentimeter halfway through as well, so sort of a bit more interactive. Trevor, next slide, please. So just as a recap, for the HRA process, there are 3 tests that we were talking about last time, which is a proposal directly connected or necessary for the management of the site, which is, as I was saying before, not often used. It's sort of to do with the conservation management of the site. And then there's a screening test, which is there going to be likely significant effect, either alone or in combination? And then the appropriate assessment at the end, which is, can it be ascertained that the proposal will not adversely affect the integrity of the site? Trevor, next slide, please. So what happens if you go through all those tests and you find that there's a project which you can't show that there is no adverse effect on site integrity? What happens next? Well, obviously one option is that you have to refuse the permission, plan consent, or other license or consent permission that is subject to the HRA test. There is also the derogation, which we tend to abbreviate to EROPI, IROPI, which stands for Imperative Reasons of Overriding Public Interest, or sometimes Importance, depending on which book you read. So there's 3 more tests if you want to grant a derogation. First off, are there any alternative solutions? The second one is the proposal of imperative reasons of overriding public interest? And the third one is, are there compensatory measures that can be put in place? And they are there to ensure the overall coherence of what we call the National Site Network, which is the SAC, Special Area of Conservation, or Special Protection Area Network. And all 3 tests have to be met in order to grant this derogation. So for alternative solutions, I'll go through each of these tests in turn. Alternative solutions. We would normally expect a developer to explore all possible alternative solutions. And this is just an alternative way of carrying out that development, carrying out that proposal in a way that would have no impact or would not have an adverse impact on the integrity of a European site. So things could include alternative locations. For linear projects, it might be changing the route slightly. It could be to do with different scales or designs of the development. The size of the development could be reduced so that there's no adverse effect. Other alternatives that would need to be developed. This test can be quite subjective. It depends on the definition of what the proposal is all about, and so can be made quite narrow. So, for example, for offshore wind, where there's tests being done for that, it can the alternatives or the outline of the project has been to develop wind energy generation offshore. So alternative locations and routes were solely focused on alternatives offshore. But elsewhere, you might want to look at, for example, a development relocating a housing development somewhere else, or those sorts of things. Next slide, please, Trevor. The next test is, are there imperative reasons overriding public interest? Now, this is really to balance the political desire for a development to go ahead against the harm that it will have to the environment. So, as I say, it's generally speaking quite a political assessment. But what it does mean is it rules out sort of private interests. So somebody wanting to build a single house for themselves where it would have an adverse effect on the integrity of a European site, that wouldn't be deemed to be in the public interest for that to be granted a derogation. We've had very few of these derogations in Scotland because of this test of being in the public interest. Until recently, the only cases that we've had were to do with a road being built out to Mallaig, or improvements to the road to Mallaig, and improvements to, repairs to the West Coast Main Line near Motherwell. Quite a few of the wind energy cases in the offshore area, and also a few other renewables schemes onshore, pump storage, and also associated electricity power lines are now coming through with this derogation, because there is public interest, and ministers have said that that's the case. So it's quite a high bar, this one, the public interest test, although it's becoming slightly easier for people to follow it. Next slide, please, Trevor. And there are also limits to when those overriding reasons can be. So, for example, and this is set out in the Habitats Directive and also in the Habitats regulations. So anything to do with public health, public safety. The third one, which is set out, beneficial consequences of primary importance to the environment, is quite difficult to define, and I'm not quite sure if there's any examples of that ever. And then there's the fourth one, which is basically any other imperative reason, but that has to be subject to the opinion of the Scottish ministers. So the first three don't necessarily need to be approved by Scottish ministers, but for anything else, then it would need to be approved or subject to the opinion of Scottish ministers. Next one, please, Trevor. So the third test of all of this is that compensatory measures must be provided, usually by the developer, and these are to offset the negative impact of the plan or project. It's very rarely that you'd have a one-to-one compensatory measure to loss. So if there were 1 hectare of habitat lost, we would expect to see more provided as compensation, and that's partly to offset the risk that it wouldn't actually work. And this is very often where our advice would be sought, is on whether or not compensatory measures that are provided or proposed by a developer are suitable, that they would work, that they're sufficient. So these measures could include designation of an alternative site, an alternative SAC or SPA. It can include extending or restoration of the particular habitat that is being impacted, either within the site or elsewhere. And increasingly now, where it's where the derogation is being used to offset losses to species, measures to protect breeding populations, and that can include things like predator control in the breeding sites, removal of invasive non-native species to increase the area available for breeding, basically to increase the numbers of birds, usually birds, that can breed in those sites. Next one, please, Trevor. There is a slight difference which has just come in to the regulations in the last, in May, a couple of months ago, for compensatory measures for offshore wind generation. And this applies only to offshore wind generation infrastructure in the marine environment. So not many of you probably encounter this, but whereas before I was saying that compensatory measures have to be there to offset the loss of particular habitat or species, and therefore would be like for like. This new measure sets out a compensation hierarchy, and this is all set out in Scottish Government guidance. And at one end of that hierarchy is the possibility of a non-like for like compensation. So replacing or enhancing breeding opportunities for a different species of seabird that was being impacted by an offshore wind farm, for example, or enhancing a different habitat to the one which is being lost. And the idea there is basically that it can be quite difficult to find compensatory measures for everything that's being lost. But if there's an overall enhancement to the environment, then that is deemed to be acceptable. This is a change that's also been made south of the border in England and Wales. It's almost exactly the same across the whole of the UK. But as I say, this only applies to offshore wind generation infrastructure in the marine area. It doesn't apply in terrestrial areas, and it doesn't apply to anything that's not to do with wind generation. Next slide, please, Trevor. So the answer to that really is that it's the competent authority who decides whether to give an OROPE derogation. So that would be the local planning authority or whichever other authority there is. They must consult the Scottish ministers beforehand and have regard to their opinion. This is apart from, of course, if that competent authority is Scottish ministers, and we know that the likes of ECU and Marine Directorate, of course, can't consult ministers because they are Scottish ministers. There is a slightly odd process that happens now, that if there is a priority habitat, and there's a list of priority habitats which is set out either in the Habitats Directive, we've got a list of them on our website as well. But habitats like blanket bog, like some of the woodland habitats as well, Caledonian pine forest, for example, and a few others. If that is going to be impacted, then the Scottish ministers must first consult the Joint Nature Conservancy Council, JNCC, and the 3 other UK governments before giving its opinion. This is a sort of a Brexit fudge, really, which before we left the EU, in these sorts of circumstances, then Scottish ministers would have to consult the EU. And this was put into place because to replace that. It's only happened a couple of times. So the answer to the previous question there was, who makes the decision to give an ORP derogation? It's the competent authority that makes that decision. Obviously, there will be quite a lot of input probably from the developer, who will be making the case that their development is in the public interest. But clearly, the competent authority makes that final decision. But having also generally consulted with Scottish ministers to make sure that that is acceptable. The final part of that, the three tests about the compensatory measures, it's the Scottish ministers that must secure the necessary compensatory measures. Although, of course, the Scottish ministers will look quite heavily towards the competent authority to ensure that those compensatory measures are secured as part of whatever consent or permission that is given. NatureScot, of course, will have a role in advising whether the compensatory measures are acceptable. But the buck ultimately stops with Scottish ministers to make sure that compensatory measures are in place and are working. And in many cases, it's expected that some areas of, for example, restored habitat or improved habitat will then be designated as part of the SAC network. So that is something which the Scottish ministers are responsible for doing.
Good afternoon, everyone. I'm Viv. I'm Planning and Renewables Manager with NatureScot. I manage the team of planning advisors who lead on our input to local development plans. And as part of that work, they will give advice on HRA of the LDPs, doing that with input from our national operations team. I've only got a few slides on this because one overriding thing I would say to start with is there is no real difference in the process, whether you're assessing a plan or a project. So the tests are the same as the material that John has already covered. The main difference is in the level of detail. So the HRA of an LDP is a higher level assessment, and it's generally based on existing knowledge. So rather than saying you need to go out and do 2 years of survey, as we would in support of a proposal, it's based on what we know already. And generally, we seek to confirm there's no adverse effect on site integrity before the plan is finalised and adopted. But there will often still be a requirement written into the LDP for project level HRA to be carried out. So it's really best available information and how far we can take an assessment at that scale. And a key piece of advice that we give is that HRA should be viewed as part of the plan making process rather than as an add-on. So really integrate the work and begin it early for best results. So we strongly recommend that we're involved early on in thinking about HRA, and then also when there are drafts of the HRA record. And there should probably be a couple of those as things move along. And that gives us the chance to confirm the work carried out and highlight any issues that need to be resolved, essentially trying to catch it early. And it also means that the HRA, in common with the strategic environmental assessment, can properly influence the content of the LDP. Next slide, please. So I'm aware there's been a bit of interest recently on site assessment and what to do with that. So part of our role is in giving comments on the results of the call for sites, is to give advice on connectivity to European sites. So depending on the information provided to us at that point, it can be as simple as flagging that potential allocation X has connectivity to European site Y, and therefore it should be screened into the HRA. A lot of the work on screening sites can be achieved via work on the SEA, which should, as I've just said, run concurrently with LDP preparation. And as the SEA requires the responsible authority to assess both the preferred and alternative sites, it's an ideal way to highlight sites for HRA. One of my team recently described this as using the SEA work as a mini screening exercise for all sites. I think that's quite a good way to put it. We, as the key agencies, developed a local plan site assessment and SEA checklist that can help with that process, and we can provide a link for that if you don't already have it. What I would say is that we're not able to comment on all the sites that arise from call for sites. Again, Key Agencies Group put out a little note on that recently, and we explained how we would screen sites for our comment. We basically don't have the resource to go through everything, but our criteria for deciding to comment does include potential connectivity to European sites. Nevertheless, no comment from us shouldn't be taken as evidence that there's no connectivity, and planning authorities should satisfy themselves that they've identified all relevant sites during their screening process. Next slide, please. So that's just really a little summary of what I've said. You know, like, do start thinking about it early, involve us, keep it simple, and you know, in common with that, don't overthink it. And a little extra thing there in terms of, don't make decisions early on thinking that you can rely on a general policy to deal with things. But again, you know, we would flag that sort of thing to you as we go through.
So the final three topics that we've got today, subject to anything else that comes up in the questions afterwards, are really just to follow up on some of the points that were raised at the last session, and to sort of drill into a little bit more and go over again some of the topics that are associated really with HRA, rather than sort of going through further parts of the process. We've pretty much covered all of that now. So the first one that came up a bit in some of the questions last time was to do with intrinsic mitigation. As a recap, this is something which has cropped up really from case law, to do with the screening stage, what we call test 2, which is the test of likely significant effect, where European case law has sort of gone backwards and forwards a little bit over the last few years about what type of mitigation can be taken into account at that stage. To start off with, it was the court was quite firm to say no mitigation could be taken into account at that stage. I think their logic was that if anything needs mitigation, therefore it must have a significant effect that needs to be assessed further in an appropriate assessment. But that's been tempered slightly by a more recent case, which says, well, you know, there are conditions that and mitigations and ways of working that are required anyway for a lot of developments, no matter where they are, and that they're not being put in specifically to mitigate the effects on a European site. So that sort of brought out the concept of intrinsic mitigation, which basically, as I say on there, is standard for a type of development that is being proposed and is not bespoke and being put in place simply to mitigate the impacts on a European site. And those sorts of measures can be taken into account in a likely significant effect test. The logic there is that otherwise you're basically assessing a different project if you strip out all the mitigation that has to be put in place in any case. You're stripping out you're assessing a different project and then saying, oh, but if you add this other mitigation that was going to happen anyway, then there's no adverse effect on site integrity. So next slide, please, Trevor. So examples of this. It's quite difficult to sort of think of lots of examples, but there's a lot of pollution control measures, silt control measures that are often required for working anywhere. And obviously it will depend on different types of development, but those sorts of things are often required anyway for every plan, every project that happens. Same for the requirements for species licenses. Someone who says, well, I've got to have a species license to, I don't know, for to do with birds or disturbing birds or anything like that, that would be required no matter where the project is. If there's those sorts of species in the area, bat licenses is another example. So the requirements for those can probably be incorporated into that screening test. The same for any of the requirements that are required for some of SEPA's license environmental authorizations, now used to be CAR. Any of those sorts of requirements that would be needed anywhere if you're working if people are working in or affecting a water environment, no matter where it is, then those sorts of requirements could probably be categorized as intrinsic. There's a couple which are a bit in the grey area slightly. So requirements for positive effects of biodiversity. Some of these measures could be considered a bit more compensatory in nature rather than mitigation. The requirements to provide different habitats, or putting in bird boxes. Some of it won't be connected at all with impacts or mitigating impacts on European site features in any case. Some of it's just wider biodiversity requirements. So that would need to be looked at a bit more carefully. Timing of works is another one which can go either way. Somebody might say that they're proposing to carry out particularly intrusive works outside of the bird breeding season and therefore won't disturb any protected bird species in an SPA. And that's fine, but that would only be considered to be intrinsic if there's no other way that they could do that work outside of that period that they're talking about. And for some developments, timing can slip. So whilst somebody might say, to start off with, we'll be doing the work outside of the bird breeding season, a few years down the line when finally contracts are signed and what have you, things can slip, and then you find that actually without any sort of controls in place, then they might start to do some work outside of a closed period. So again, that's something which needs to be examined, and if there's no other way that they could do something other than in a particular time of year, and that means that there's no connectivity to the features of a European site, then that would be intrinsic. But otherwise, you just need to be a bit wary about that. So the next topic that we were going to cover was just a bit more on cumulative effects and in combination, which again is a part of the screening test, which is that the competent authority must determine whether there's a likely significant effect of the plan or project alone or in combination. Now, very often a test is done just alone. It's if there's a likely significant effect of the plan or project just on its own, then the cumulative effect or in combination test doesn't need to be done because you've already screened something in. So this normally would be looked at if the project that you're looking at or that you're screening on its own has no likely significant effect, but in combination with others that are in place or could be in place, there would be basically a cumulative impact of all those projects stacked on top of each other. And the point about this is to avoid a sort of a death by 1,000 cuts scenario where lots of projects have on their own no likely significant effect, and then suddenly find that there's lots of projects which have been permitted and the relevant European site is significantly degraded. So the other thing to say about this test is that although it's one which comes up in the screening stage, which I say is test 2, and that's quite explicit in the legislation, it's kind of only implied that you then take into account in combination or other projects, or the in combination effect of the project at hand plus others, it kind of implied that you take that into account at the appropriate assessment stage as well. But it is mainly used as a way of screening plans or projects in or out. So do you get asked quite often, what should be included? Well, obviously anything that is already happening on or affecting the site in question. So anything that's been permitted and has been either agreed and permit with a planning permission, planning consent in place, or other consent in place, or something which is being built. Obviously, that would be quite easy to see. Developments that are in construction, so there's going to be a future additional impact, and projects which have not yet been started. So we do have situations in some of the casework that we get involved in where projects might be permitted, and then there's quite a long lull before they're actually started, whether that's to do with finance or whatever. And just because something hasn't been started doesn't mean it gets discounted in this test. If there's still a valid permission or whatever in place, then that needs to be taken into account. The last one there can be quite difficult to identify, which is projects which are in the permitting process. So in other words, they're working their way through some sort of regulatory process that's relevant here, or ones which you're pretty sure are likely to be submitted for permission. There's been a lot of prior work going ahead to draw up plans, to do survey work, to maybe there's been a lot of stuff in the press about some of these projects, that sort of thing. Those ones where they are not yet, it's not certain yet whether or not they will be submitted and will be in effect. There has to be a judgment call there about how likely that is to go ahead, and relating to the plan or project that you're looking at that time, which obviously will be in the statutory process already. Whether or not you need to, it's a judgment call, as I say, whether or not you need to then take into account the ones that are following. But generally speaking, it would be good practice to, in the assessment that you're doing, at least have a view whether or not you've taken into account some of these other plans or projects. What's not included is anything that was completed on the site before the site was designated. That's part of the baseline. It's obviously was there and contributed to whatever condition the site was in when it was first surveyed, and when ministers decided first to designate that site. So those sorts of projects, those sorts of developments can be excluded. So things like large road schemes that have been put in place before a site was designated, or close to a site in the offshore or marine area. Things like aquaculture that was there before site was designated. Those sorts of developments can be excluded, unless, of course, they've since got bigger or changed scale. So I'm not going to spend a huge amount of time. I haven't got that many slides on permitted development, but I know it's quite a tricky area for a lot of people. So there's three main regulations in the habitats regulations for this: Regulation 60, 61, and 62. The basic thing with permitted development and European sites is that automatic permitted development rights are removed for plans or projects that are on or that are affecting a European site. And therefore, this engages the prior approval process which a developer must apply for anything that would be otherwise be permitted on the permitted development order, if it's likely to have a significant effect on a European site. So it's sort of that second test, that the screening test, that is would be key to this. So that's sort of the basic principle on that. So next slide, please, Trevor. So Regulation 61 is the next one. It's slightly strange in some ways in sort of working through it, but what it says is that a developer may consult NatureScot on whether or not a project that they've got will have a likely significant effect on the European site. Now, this doesn't mean that the developer must consult NatureScot. It just gives them that option to consult us. But if we do get consulted, then we must notify the developer and the local planning authority of our opinion. And the other thing that the regulation says is if we determine that there is no likely significant effect for the project, then this is conclusive to rely on the fact that planning permission can be granted. It will be granted through the general permitted development order. So this stage really is, I think, originally designed as a sort of an option for developer to either get us to conclude that what they're proposing to do will have no likely significant effect on the European site, and for them to then be able to essentially prove to the local planning authority and anybody else that yes, they could go ahead with that work under permitted development rights, and that within that process, then we have to also tell the local planning authority that that is the conclusion that we've come to. Next slide, please, Trevor. So Regulation 62, which is the final one on this, again, it says a developer may apply to a local planning authority for essentially prior approval. But when they do that, then the local authority must assume that the proposal will have likely significant effect, and therefore must consult NatureScot, which is a slightly odd way of doing things, but that's the sort of the assumption that happens there. Again, if we determine that there will be no likely significant effect, then that's that. Then the work can go ahead under permitted development. But if we instead say that there is likely significant effect, then the local planning authority must carry out an appropriate assessment, which is the third part of the HRA test. And a local planning authority cannot give approval unless there is no adverse effect on site integrity. So the question that comes out on this one is, well, how do we embed mitigation that might be needed, that would be concluded through the appropriate assessment to avoid any adverse effect on site integrity. And I know that this can be done in a couple of different ways, either by going back to the developer to get them to amend their proposal to include any mitigation that has been deemed needed, necessary, or by adding a condition to the prior approval process. Either seems to work, but what is implied by this is that at some point in the process, if mitigation is needed to avoid an adverse effect on site integrity, then it needs to be somehow secured through the process that goes ahead. So the process is basically that involves both Nature Scott advising on whether or not there's likely significant effect. And if that is the case, if we say, no, actually, there's no likely significant effect on this, and that's either because the developers come to us in the first place for that reassurance, or because if they haven't gone to us in the first place, but have instead gone to straight to the local planning authority, and the local planning authority has consulted us and we've said that there's no likely significant effect, then that's the end of the process. So the appropriate assessment is only kicks in once, or if we've said that there's no likely significant effect, and that's when the local planning authority must carry out an appropriate assessment. There's obviously that's sort of the reading of the regulations, and there's obviously will be different ways in which it's implemented in practice, and in particularly for different classes of municipal development, or for different types of projects or different types of developers. But that's essentially the outline of the process.